Hi, everybody. Thanks so much for joining us today. You are here for a Get Legit webinar on employee and employer management. It is great to have you here. I'm going to do a few housekeeping in just announcements before we get started today. For those of you not familiar with us, your host today is the Nevada County Cannabis Alliance. We are a local nonprofit trade association based here in Nevada County, California. We represent the local cannabis industry. We provide policy and advocacy work as well as year-round education, and are proud members, proud members of Origins Council, our statewide lobbying organization. And if you want to learn more about us and support the work we do and webinars like this, you can go to nccannabisalliance.org. Please consider becoming a member or making an impactful donation. You also can learn more about our statewide advocacy through Origins Council at originscouncil.org and consider becoming a sponsor of Origins Council or making an impactful donation. A couple notes and other updates I want to make everybody aware of. There are a number of great educational opportunities coming up, and winter is always, I feel like, the best time to take care of book work and business stuff while we are not in the fields. This coming Monday, January 30th, our friends at the Trinity County Ag Alliance are offering a Start Tax Season on a High Note webinar. Please check out the Trinity County Agricultural Alliance for more information on that. It is this coming Monday at 5:30 p.m. Alliance members, you can find information on that on Slack. Also, for those of you in Nevada County, this coming week on the 1st of the month, the Nevada County Department of Agriculture is hosting a cannabis pesticide safety and use workshop. This is an in-person workshop at the county building. It does require pre-registration, but it is free, and is for those who want to review pesticide use and safety, who need continuing education credits or want to prepare for the qualifying trainer exam. And then I want to mention our next Get Legit webinar coming up next month is all about audit prep, Audit Prep 101. This is presented by Holly Carter at Oxalis Integrative Support Services, and it will be on Thursday, February 16th. Definitely stay tuned for this. It will go over compliance binders, SOPs, record keeping, and much more. And so with that, for today's webinar, I want to encourage everybody to participate. You can use the chat feature here in Zoom. You also can use the Q&A feature, and we will make sure to get to everybody's questions throughout the webinar. And so these are what you make of them. Your participation is encouraged, and please do that. With that, you are here today for Employer and Employee Management 101. I am so thrilled to have Sarah Smale here with us. Sarah is a 2005 graduate of the University of California, Berkeley School of Law, and she is the owner of Sarah L. Smale, PC, a Nevada City, California law firm. Sarah became interested in labor and employment law during her first year of law school as a student counselor at the East Bay Workers' Rights Clinic, which aimed to provide free information to low-income and unemployed workers. In her current practice, Sarah helps small businesses, including cannabis operators, develop and implement compliant employment practices and risk management procedures. When disputes arise, she also represents businesses in court and labor commissioner proceedings. Sarah, you are a pillar for us here at the Alliance in all that you do, and we are just so grateful and thrilled to have you here. I will pass the mic over to you.
Thank you so much, Maggie. I appreciate that introduction. Hello, everybody. I can't tell who's on the line, but I'm sure we know each other, a lot of us. So I also work with cannabis businesses in other arenas beyond labor and employment compliance. I do corporate formation, contractual work, and unfortunately, these days, more and more and the dispute arena, which includes various types of lawsuits and wage claims and employment law problems. So I'm going to go ahead and try to share my screen. I did finally make slides the third year that I've done this presentation. So bear with me. We're good? Okay. So this is just a blurb, about me, my contact information. If you want to reach out and talk more, these seminars don't create an attorney-client relationship. This doesn't constitute legal advice. So with all those disclaimers, I would encourage you that if you have questions related to your employer or hiring compliance, or if you're having any current issues, to reach out to me or another attorney that can help you really specifically analyze your situation. There is a ton of nuance in the employment law context. So the first thing I always cover whenever I do these presentations is what makes an employer. So an employer is any person who directly or indirectly or through an agent or other person employs or exercises control over the wages, hours, working conditions of any person. And so this is becoming really, really important over time here in California, because the California laws are consistently moving away from allowing independent contractor classifications and just defaulting to employees. And those are distinctions that are very important for reasons we'll discuss in a moment. So I often see folks trying to avoid becoming employers because it's difficult. You have to register with the EDD, pay your workers' comp, run people through payroll, give them a bunch of pamphlets. And so what I see happening frequently, particularly in the cannabis space, and particularly in the earlier years of regulation, is one of two things. Number one, paying folks under the table. This was very common in the traditional market when laborers at farms were being paid on a percentage basis at the end of the season, or some sort of weight calculation that is based on how much they're able to trim, for instance. So that is something I see often. And then the second one is misclassifying employees as independent contractors. So the first instance, which is paying people under the table, incredibly problematic because nobody's reporting them, nobody's paying taxes on them, and you don't issue W-2s or 1099s. And if that comes to the attention of one of the various agencies that regulate employees in California, the EDD, the DIR, the Department of Industrial Relations, the Workers' Comp Division, it can create a whole avalanche of problems. So just do not do it. The second and more common issue that I'm seeing arise, particularly again in the cannabis field, is mislabeling folks as independent contractors. And so I think there's oftentimes this sense that, it's going to be so difficult to register them, put them on payroll, pay them as, you have to pay employees at least twice a month. And so oftentimes cannabis operators, particularly if your income is coming from one large sale at the end of the long season, for instance, I see people try to enter into these deals where they can still do the old school traditional market payment arrangements of percentages or piece rates and pay them at the end of the year. So while it is easier from a paperwork perspective, it's incredibly problematic because it's more often than not, this person is not a true independent contractor. So there's various tests of what makes somebody an independent contractor in California. The most common one is what is called the ABC test. This was a test that courts have developed over the years. It's what we call case law, and it was made applicable by statute under AB 5, which was passed in, I believe it was 2019. So under the ABC test, there's three main factors to consider in whether or not somebody is a true independent contractor. Keep in mind that folks will be, the default starting assumption is that any laborer that you have working for you is a true employee, which means they need to be reported, taxes need to be paid, you've got to issue W-2s and other record keeping requirements we'll touch on briefly later. So there's three factors. The first factor is control. Any true independent contractor should be free from the control and the direction of the hirer as to performing the work. So that would be, you're not telling them what hours to come in. You're not telling them how to do your job. These are the nutrients we use. This is how we apply it. This is what our policies and procedures are. That is far more like an employee than an independent contractor. The second factor, which is usually the killer for trying to misclassify folks as independent contractors, is the person that you are hiring should be engaged in a business that's outside of your normal business. So for instance, if you are a cannabis cultivator and your business is primarily centered around cultivating cannabis plants, if you hire somebody to come and work for you to run your farm, that's not a separate business from what you're doing. And then the third factor under the ABC test is that the laborer is engaged in an independent trader business. So that means that they're generally performing work for multiple folks, right? They're not just working for you. So these would be people like true independent contractors would be you hire people to come in and build you a barn on your property, your bookkeeper, folks that are coming in and doing really specific tasks that are outside the scope of what you're doing on the day to day. So again, you can write up a contract that says you're an independent contractor, and the agencies and the courts will not be bound by that. And the reason for this is because oftentimes the worker is they have far less bargaining power than the hirer. And so if a hirer comes to a laborer and says, hey, you're going to have to be an independent contractor, I'm going to pay you X amount of dollars, I'm going to pay you at the end of the season, sign here, you get nothing. The idea behind California law and the policy that's underlying these assumptions of employment status is that there's just not equal bargaining power here. So keep that in mind and make sure that you actually meet the test, and understand that regardless of what you put on a piece of paper and contract in your employee handbook, they need to actually meet the test in fact and not just in writing. And it's important to properly classify folks as employees if they're employees. And the reason for that is because it can create a whole host of problems. Investigations in terms of when does this come up? When does it become an issue? It usually becomes an issue when a laborer, tries to file for unemployment, gets injured, files for workers' compensation, tries to go and file a wage claim. So generally speaking, in my experience, the investigations are triggered by the laborer, current performer, going and filing a complaint with one of the multiple administrative agencies that oversee employment law in California. Sometimes you hear about agency audits. For instance, the Employment Development Department just auditing records in various industries or regions. It could pop that way, but more often than not, when I see it, it's because a laborer has made a complaint. And then there's lots of penalties. So if it is determined that you had improperly classified somebody as an independent contractor when they were truly an employee, all sorts of fallout can occur. And I always tell people, I hate to be fear-based, but it truly can be a bankrupting event. You will be responsible for all of their unpaid wages, which, if they, for instance, are not exempt as properly as an employee, this will include all of their overtime. We often see in the farming world that folks are working 10, 12-hour days. And if you're paying them on a flat rate or a salary or some lump sum percentage, that means that they're not getting all of their overtime. And the agencies will go back, calculate all of their hours, which of those hours should have been overtime, and hit you with a massive OT liability. Meal and rest break violations, failure to timely pay. For instance, so if you don't pay all wages that are due when they're due, you can be liable for an entire day's worth of wages for up to 30 days. Misclassification penalties. This is penalties directly aimed at, you misclassified somebody as an independent contractor. Now we're going to assess you a fine for that. It can range from a first offense penalty of $5,000 to $15,000 for a willful misclassification, and up to $25,000 for a pattern or practice. So that would be, you've been improperly classifying folks as independent contractors over a period of time for everybody that's working that's on your labor force. Shaming. They will make you post a notice at the location where you're running your business, indicating that this has been an issue for you. There's mandatory reporting. So for folks on the call that hold a cannabis license, you're required under the DCC regulations to report that within 48 hours. And that's if there's a judgment against you in court or an award in an administrative agency, like a wage claim that we see with the labor commissioner. And now the Secretary of State has a little box you have to check when you're filing your statements of information annually for corporations, biannually for LLCs. You have to indicate whether or not you've had a labor judgment. And that is just sort of the beginning of it. There's other penalties that can attach. So the point is that it can add up to be a really expensive issue for you. All right. And I also want to point out another reason why this is really scary. Generally speaking, attorneys recommend that folks incorporate and hold their permits and licenses under the name of an entity, whether it's a corporation, an LLC, a B Corp, whatever that is. And part of the reason is to provide some liability protection from the owners, which is what we call the corporate veil. So in the arena of wage and hour law, any person acting on behalf of an employer, and this could even include supervisors that don't have an ownership interest in the company, they can be personally liable for wage violations. And that will certainly attach to owners, directors, managers of an LLC, managing agents. And that the idea behind that is that if a business is paralyzed and goes bankrupt due to a wage claim, they want to ensure that the laborer still has somewhere that they can try to collect that judgment. And so that is why they allow them to pierce the corporate veil and come after you personally for wage claims. So it's pretty dangerous. I do want to quickly touch on other situations I get asked about a lot. Temporary labor. You can bring somebody in for a single day and they can still technically be an employee. If you pay somebody over 100, once you pay more than $100 in taxable wages in a quarter, you need to actually open up an employer account with the Employment Development Department. So just because somebody's there briefly or it's seasonal, that doesn't mean they're not employees. Entity owners, you know, I see this a lot where people will come to me and say, Sarah, if I give this employee a 2% interest in the corporation, does that mean that I don't need to comply with the wage and hour law? No, not necessarily. Entity owners, and whether or not you will then be considered an employee that's entitled to a minimum wage, you know, that is something that depends on your entity type, tax elections, whether or not you're a pass-through entity. Always check with your CPA to ensure that however you're compensating yourself as an owner is compliant with, you know, the various rules, including whether or not you need to be paying employment taxes on any income that you're running through the business. Corporate officers. So keep in mind that corporate officers, so anybody that is deemed, you know, the CEO, the secretary, the treasurer, those boxes that we're filling out when we create business resolutions behind the scenes or when we're filing our statements of information, anybody that is an officer of an entity is a statutory employee. It's a default presumption that is set in law and you can't contract around it or work around it. So be very careful. I often see folks that want to bring in a highly skilled master cultivator, and part of what that person wants is some sort of officer position with the company. You know, it looks good on business cards and resumes. Just keep in mind that that can create some significant issues in terms of determining employment status. Interns and trainees, this comes up a lot where people want to classify a laborer as an intern. They find somebody that wants to learn about the cannabis industry, they're really excited about it, so they want to put them down as an intern. And more often than not, that is not sufficient for them to qualify to get them out of the minimum wage and employment requirements. So always check with somebody about that before you want to classify anybody as an intern or a trainee. It is very difficult to meet those requirements. They're generally inapplicable and they're easy to beat if somebody turns around and files a wage claim against you. Family, this is something else that comes up pretty frequently. I think that there's this misunderstanding out there that if somebody is related to you as a business owner, that therefore they're not employees, you can pay them under the table later under other arrangements. Generally not the case. First of all, it only applies to parents, spouse, domestic partners, or children under the age of 18. So if I go out and I start a business, I cannot hire my brother and then try to take advantage of some of the reductions in tax liability just by virtue of the fact that he's my sibling. Same thing, I have a 26-year-old daughter. I couldn't hire my daughter and then take advantage of some of the tax exemptions because she's no longer a minor. Then the second thing that will often prevent you from taking advantage of the various tax benefits to hiring family is it's not even available if you're an entity. So if you're a corporation, generally when you're an LLC, you cannot take advantage of any of the family employment benefits. And so what that means, if somebody is a qualified family member and they're working for you personally or in a partnership, then that actually does not mean you pay no taxes and you don't report them. It does allow you to exclude having to collect unemployment taxes, state disability insurance. You will still always have to pay the personal income tax requirements for family employees. And there is a really useful employment development department handout. It is the DE44. If you Google California EDD DE44, it will pop up and it will go into more detail in terms of what is a family employee. Okay, so if you're an employer, now what? The first thing that I recommend everyone do, every year the Employment Development Department issues an updated employer guide through their website. I was looking through the 2023 version earlier this week. It's incredibly long and complex, and there's a ton of information, but it's good to flip through. It will often answer questions, you know, when do I need to report a new employee? You know, how much can I pay somebody before they're, you know, I need to open up an EDD employer account? So that provides some really useful information. And then there's also a lot of good information on the Department of Industrial website. The Department of Industrial Relations website. You can, you know, Google them too. They provide a lot of the mandatory handouts that you need to give to folks at the time of hire. There's a lot of documents you need to give people, just mandatory personnel file. You've got to get the W-2, the I-9 to confirm that they're legally permitted to work in the United States. And then lots of handouts ranging from sexual harassment prevention and rights all the way up to, you know, pregnancy, sick leave. So just check. If you just Google again, California DIR, mandatory handouts, there's a lot of places where you can just get the list of those. What I do for myself is I just park them all in a folder, you know, and then I will scan everything I give to an employee and keep it all and just have it on your servers, because you can get in trouble if you don't hand out the pamphlet related to really specific rights that may not even apply to any of your workers. Okay, so then the other thing also is the Employment Development Department is one of the agencies that has really, really helpful customer service representatives. So if you're not sure if you need to open up an EDD account, whether or not somebody is already under your system, things like that, you can just call them up and ask them. And as long as you're just trying to proactively comply with the law and you're not quite sure where to go, in my experience, the EDD representatives are incredibly helpful and will help you walk through even getting into your account, registering it, all of that stuff. So take a look, and if you can't find the information you need on the EDD's website, give them a call. They're really helpful. Also check if you have a bookkeeper or CPA. A lot of times those folks will help you with employment compliance. So the second thing I want to touch on is there's this really strange nuance in the California regulated cannabis industry where, you know, in California, the Department of Industrial Relations issues these documents called wage orders, and they apply to various industries, you know, ranging from restaurant workers, clerical workers, ag workers, there's lots of them. And when California implemented its regulated cannabis system, they put cannabis cultivation employees under wage order number 4, which applies to professional, technical, clerical, and mechanical occupations. It's strange, and it has to do with California deciding that cannabis cultivation was not going to be deemed ag. So oftentimes people will come to me and say, oh, well, these are agriculture workers, so I have different overtime requirements. That's actually not true. So I always tell folks, download and review wage order 4-2001. If you have an employee, you're required to post it at the job site anyways. The document's only 4 or 5 pages long, gives you a lot of good information, including overtime requirements, meal and rest breaks, how to determine whether or not somebody's a salaried employee, posting, all of that. So just always familiarize yourself with that document if you have any employees. Okay, wage and hour basics. This is also covered in, you'll see this all if you review the wage order. This is not an exhaustive list, but overtime for cannabis cultivation workers and most professions that would be related to these sorts of businesses, office jobs, your bookkeeper, anybody that's working, even if you're not a cultivator, if you have some other license type, this probably applies to you as well. Anything over 8 hours a day, 1.5 times the regular pay rate. Keep in mind that the California minimum wage increased to $15.50 as of January 1st. And that is across the board, no matter how many employees you had. Previously, for the past few years, we've been having this sort of double tier system for increasing the minimum wage every year. And it mattered whether or not you had 25 employees. That's gone, it's phased out, it's $15.50 everywhere. And then some towns and counties have even higher. San Francisco, for instance, will have a significantly higher minimum wage. Okay, so then anything over 12 hours a day or on the whole 7th day of work, you have to pay them 2 times their rate of pay. Meal and rest breaks. You have to give employees, for every 4 hours that they work, they're entitled to a 10-minute paid break. And it's not just a break from working when things are slow, but they need to be free from employer control, which means they can't be answering the phone if it happens to ring or on call. Similarly, for meals, if somebody is working more than 6 hours a day, they're entitled to 1 30-minute meal break. Again, uninterrupted. You can't have them monitoring the phones or looking out for things. You know, you see this a lot in, for instance, retail or the restaurant industry, where people are given their meal breaks or their rest breaks when things are slow and they're just eating at their desk, but they're looking out for phone calls or customers. That is actually inappropriate, and you can get hit with a penalty for that. So 30 minutes, this does not have to be paid as the rest breaks do. And then if they work less than 6 hours a day, an employee can waive their meal period, but you actually have to have a written waiver on file before that can be implemented. And there's some paid sick leave requirements. You can easily find information about this. Essentially, anybody who works for you is entitled to have a minimum, I believe it's 24 hours of sick time a year, which they can begin using after 90 days. There's different ways to calculate how that time is accrued, but just keep that in mind, when you're setting somebody up. I have actually been shocked to see that some of the major payroll providers, I'm not going to name who did it, but there's Paychex, ARP, there's Gusto, there's various businesses, Intuit through QuickBooks, that will actually run your payroll for you. And I've seen some of those providers not calculating the sick pay for California customers. So make sure that they're doing that. Ask your representative. If they know what you're talking about, go and see somebody else. Bonuses, earned versus discretionary. I always tell folks to be very careful about paying employees, having a portion of their compensation structured as a bonus, a guaranteed bonus. At the end of the year, everybody's gonna get $1,000 at harvest. Or if you produce X amount, then you're gonna get this additional amount of money. Those are considered earned compensation. So if somebody is under that sort of payment structure and then they leave halfway through the season, there's personality conflict, other problems arise, they're actually still entitled to some prorated amount of those bonuses because it was considered part of their earnings. That does not apply when somebody is not entitled to, but when somebody receives a discretionary bonus. So that would be something like holiday bonuses. The company has a really good year, and then you just want to, give some additional money to your laborers, so everybody gets a couple $100 for a Christmas bonus. Things like that are not considered earned compensation, and so that analysis does not apply. This becomes really important if somebody files a wage claim against the business and they're claiming that they're entitled to overtime. So let's say that you pay somebody $20 an hour, so their overtime rate would be $30 an hour. But if you also promised them a $2,000 bonus that they would get at the end of the season upon harvest, then you actually have to go back and include that into what their hourly wage would be for purposes of calculating overtime. This becomes a massive issue when people are paid on a piece rate basis or on commission. So I always tell folks, just set them up with whatever you think is a fair hourly. And then to the extent the business does really well, maybe the market kicks up a bit, then you can go ahead and give them a bonus. Just make sure that it's a discretionary bonus. It's a safer policy for you guys as business owners. Split shift premiums. This is just if somebody has to work, for instance, the first 3 hours of the day and the last 3 hours of the day, they may actually be entitled to some additional compensation for having to cut that up in between portions of their day. Similar, there's reporting time pay. Somebody gets to the job, you don't need them for the whole time. You have to pay them a minimum of 4 hours. So there's a lot of little stuff, most of which is covered in the wage order that I strongly recommend folks get on their radar and, read the wage order. There's lots of FAQs. Okay, parting ways with an employee. This is always where, things start to get tricky. It never ceases to amaze me how protective, and I'm as liberal as they come, but California is so protective of employee rights that sometimes it just feels bonkers to me. I've had folks come to me and say, hey, yeah, I didn't pay them the last $300 I owed him, but that's because I have them on camera stealing $5,000 from me. Irrelevant. You need to pay them. So if you know that you are going to be letting somebody go, whether that is for misconduct, just business needs, the season is wrapping, you don't need people there as much as you did, for instance, during harvest. If you know that you're going to let somebody go, then you need to give them their final paycheck on the day that you let them go. Hand it to them. This would include any accrued vacation time. You do not need to pay out sick time. You do need to pay out vacation time. If you combine those things into a PTO bucket, you got to pay it all out. So do not delay. You're exposing yourself to some additional penalties if you don't pay them on the last day. And if that happens where, they started trouble on the day, they're attacking folks, you caught them stealing, you send them home, and then you're unable to get their check to them for another 2 or 3 days, just include waiting time penalties, which is 1 day worth of their wages for each of those days that you delay. Otherwise, they could file a wage claim against you after already having insulted you by bringing problems to the job site. If that they can get another day of wages up to 30 days. It's called waiting time penalties. It's just not worth it. I always tell folks, just include any even potential penalties that may attach to the termination, because it just makes it much easier in the event there is an issue down the road. When somebody quits, the analysis is a little bit different. If they give you more than 3 days notice that they're going to be parting ways with the company, you do still need to give them their final check on their last day. If they quit without notice or in less than 3 days, you have 3 days to get them their final check. And the employer is responsible for providing that check to the employee. So even if they go off the radar, they're MIA, you do need to make reasonable efforts to try to get them their money. And I always recommend that that is documented in a follow-up text, email, letter, something along those lines. And if you just simply cannot find the former worker, they took off, they fled town, no addresses, no one has heard from them, you need to contact the labor commissioner, because you likely need to remit those wages to the labor commissioner for what's called the unpaid wages fund. Okay, disputes and risk management. I will say, I've been working in the cannabis space for a number of years now, and I've been doing employment law ever since I started law school, and I am seeing an increase every single year in the number of wage claims or threats of wage claims or lawsuits from former employees in the cannabis space. So this is a big problem, because so many farmers are continuing on with the prior arrangement, which oftentimes the workers prefer. They would much rather get a percentage of what you make off the harvest, or make some amount that is tied to how much they produce throughout the season. They like that better than, for instance, just getting paid minimum wage throughout the year. And so it can be very appealing to enter into these improper agreements. But then the problem is, once something goes wrong, word is out. The various communities that are frequently working on cannabis farms, they're becoming more and more sophisticated in their knowledge of the wage claim procedure and what that looks like. Somebody can go online and file a wage claim in less than a half an hour. It's a pretty simple process. And the bigger issue is that it's incredibly difficult to win these outright as an employer, because there are so many requirements related to your record keeping, all of the sorts of penalties that I talked about before. If you improperly say somebody's salaried and then you're not keeping track of their hours via time cards, it actually works to shift the burden over to the employer, and the employer has to prove, oh, well, these are the hours they worked, here are their payroll records. If those don't exist, the labor commissioner or a judge or a jury is likely to just take whatever list the employee recreates. So I always tell folks, make sure that you are doing, timesheets each week or bi-weekly that have a blurb that say that they received their meal and rest breaks. So there's some risk management strategies that you can implement to try to stave that off. But when and if you get somebody that's throwing a big fit, my strongest piece of advice is to call an attorney and try to see if you can get that claim resolved before it gets into court or gets before the labor commissioner. Because again, it can just be time consuming. Things get really expensive. Anytime you're in litigation, the attorney's fees get crazy. It takes forever. So you have the stress hanging over your head. And I will say that I'm seeing my practice in the past couple of years, I'm seeing a steady increase in wage claims, which we're generally able to resolve pretty early on, which is nice. You can get a settlement agreement, you have confidentiality provisions, all of these things baked in. And it's just so much cleaner than having to fight it all the way, through a court or through a wage claim. And then, my biggest piece of advice that I always give people is just be a nice human, even when they're not nice. Even if you catch an employee, pocketing stuff from the job site, if they indicated they had a ton of experience when they clearly do not, taking the high road is almost always the best business strategy. Sometimes the best business decision is to eat a loss to minimize potential fallout later. And so for those reasons, it makes sense to always take the high road, be nice. Generally I tell people, meet other people where they're at. This is not the case when you're an employer. When you're an employer, take the high road, always try to be the bigger person, and don't inflame them. Oftentimes you see workers that get it in their brain that they're entitled to an absurd amount of money. I'm such a great worker, I should be an owner of this company. And you get this sort of crazy thinking, and the inclination and the instinct is to explain to them why that's not true, point out the mistakes, how they're not great, they don't have a great work ethic, they didn't do good work. And I just don't recommend it. To the extent you can just make them go away with some small payment, it's generally easier. And so I strongly encourage you, as soon as you're on notice of a claim or a potential claim, to contact an attorney. It's becoming a bigger and bigger issue all the time. If you go online and you Google wage and hour law, California attorney, you will see page after page after page of these firms, these law firms that just act as, a mill. They just take in everybody that comes through. They'll do online assessments and intakes for workers. And they do it because their entire business strategy for their firm is reliant upon, number one, it being so difficult to comply as an employer. But number two, it's easier to win these sorts of claims than in other contract disputes or other types of litigation, because there's a lot of burden shifting that exists as a function of the employer being responsible for records. So if you're going to have employees, it is worth sitting down with an HR professional, an attorney, and let them help you get some strategies in place to try to stave off these issues as much as possible. And then when and if a dispute arises, generally in your best interest to speak with an attorney immediately. And then the final thing I want to plug is that in the cannabis space, if you know that you're going to need laborers on the farm, you know, whether that's 1 or 2 people throughout most of the season, and then a larger group come harvest, one thing that a lot of farmers here locally have the option to do is take advantage of what is called a farm labor contractor. So farm labor contractors, FLCs for short, they act as temporary staffing agencies. So you can enter into agreement with an FLC, you pay them some hourly number for them to provide you with the laborers. In exchange, they handle the workers' compensation, they handle the payroll, they make sure that the workers are well versed in the wage and hour laws. So it sort of takes off some of that administrative burden. And from what I've seen from the local FLC, it's pretty reasonable rates. So if you don't want to deal with the paperwork and the headaches, I strongly encourage people to look into the FLC. I think it's Gold Coast Botanicals. Their information is probably on the Alliance website. So with that, I'm going to look at the Q&A and see. Let's see, given that you've shared here today, it seems like it would make sense to hire a labor contractor instead of hiring employees. What are the issues with this approach? That's exactly what I was just mentioning. So that is absolutely an option. However, just hiring somebody as a contractor won't work in terms of the farm labor. They've been very clear that the state is considering cannabis cultivators the sort of employer that would require contracted labor to be run through an FLC. So you'll often see people that want to contract with other third parties to come in and run the farm, but if they don't hold that FLC license, it still creates exposure for potential liability. All right, let's see, how much time do we have?
I have some other questions for you and some coming in.
Beautiful.
Sarah, thanks so much for this great information. One question is, so if somebody structured their business entity, they're sole owner operator, but they've structured their business entity so that they are the sole employee of the business.
Yep.
So if I'm it's just me, but I am an employee of the business I created, do I still need to go through all of these things to make it to be compliant with me being an employee?
Right. So that is a bit of a nuanced question. I mean, as a practical matter, if you are your only employee, then you're also your own boss, supervisor, manager. So if you filed a wage claim against yourself and your business didn't have the money, then the law would say, okay, Maggie, now you can go after your boss, who is also Maggie. So really, it sort of limits in terms of who you can chase down for money. So in terms of the tax advantages for doing that, there are sometimes good reason to put yourself on payroll. And even if you're just paying yourself a portion of your compensation through payroll as a W-2 employee, you can choose to cover yourself with workers' compensation, which is generally going to be cheaper than maintaining your own health insurance policy if you do get injured on the farm. You can contribute to the unemployment fund, the SDI, the state disability insurance fund. So there are oftentimes some benefits to putting yourself on payroll, at least for a portion of your pay. In terms of whether or not anybody's going to come after you and start penalizing you, I've never seen it happen with a sole operator. Although I always tell people this is more of a tax issue, how you want to structure your compensation to maximize your own benefits from a tax perspective. And I tell people it is worth speaking with a CPA as to whether you want to maintain whether or not you want to be a pass-through entity. It all goes through, just claims your income on your own personal taxes, or if you want to keep those things separate, and have part of the business's income taxed as an entity, and then whatever you're receiving through both profit shares and payroll, those are taxed differently. Absolutely worth, a brief consultation with a CPA. I've seen this shake down many ways. The other issue that can arise is when you have multiple owners of a company. So I'm actually, I do a lot of litigation, and some of the things that are starting to happen is, people that went into business together, you'll often see it's a group of 3 or 4 friends. They've been growing together for years. That is my brother. We're family. Nothing could ever go wrong. fast forward 2 years and shit went wrong. So it's really important, keep in mind that officers of your business entity are statutory employees. So if there's a partnership dispute and folks start suing each other, they could actually throw in a wage and hour claim to try to shake you down for some additional money. So it can get risky when you have more than one owner. It's a little bit more difficult, and it's not as likely to happen as when you have a true third arm's length party with no ownership interest and they're providing straight labor. That is the riskiest.
Awesome.
But check with the CPA. It varies so much that I don't even like to give the broad generalizations with too much specificity. It's a complex analysis based on the situation.
All right, next question we have, can you expand a bit on the need for salary employees to track timesheets?
Yeah, so the thing about salaried employees, again, check wage order 4-2001 if we're talking about cannabis, or if you're a small business that's generally clerical, retail, review the applicable wage order and it'll go through what the tests are. I always tell my clients, the nice thing about being a true salaried employee is that you're able to get around the meal and rest breaks. They're not entitled to overtime. So, you're going to get paid X amount of dollars per week or bi-weekly, regardless of whether or not you're actually working that many hours. So for instance, my daughter, she's a paralegal at a local firm. She's salaried. So if she, goes to visit family out of state for a couple of days, she's still getting a full week's pay. The reason that I always recommend that folks do still have their salaried employees document their hours is because if that salaried employee turns around, files a wage claim, and argues that they were not properly classified as salaried employees, they can go back and try to collect all of that overtime retroactively. And you can go back 3 years and sometimes 4 years it depends on what your legal theory is. So I tell people, when you are, for instance, an executive of a company that's entitled to being salaried or an admin human, like the behind the books person, there's still additional requirements. They have to be paid 2 times the minimum wage, which at $15.50 an hour, and assuming a 40-hour week, that's approximately $5,000 a month, a bit more. But on top of that, management needs to be a big chunk of their responsibility. They need to be supervising other employees. This is the executive exemption. They have to have the authority to hire or fire, or their input needs to be given a lot of weight. They're customarily exercising independent judgment. So there's a few different requirements for somebody to be properly salaried. And if it turns out that they were improperly salaried and you didn't have them track their hours, then all of a sudden you're opening yourself up for a potential overtime claim. So that's why I recommend that people do it, even though technically they don't need to do it. It's not a record keeping requirement for salaried employees, but it is a good business practice to do that.
All right, next question. I hear that there is risk to an employer for improperly classifying someone as an independent contractor. Are there also risks that the independent contractor is taking on by improperly working under that classification?
Sure, yeah. Though comparatively speaking, the law tries to put the weight of the risk on the hirer, so on the business or the person that's employing them. But there are some risks. You're risking that if you sustain an injury, file a workers' compensation claim, and you're unable to document that you were an employee, you should have been classified as an employee. You may not be able to work around that and get covered under workers' comp. Same thing with unemployment. You're also running the risk of potential exposure to I think I mentioned you can't get unemployment, and if you cannot convince whatever agency is evaluating that decision that indeed you were an employee, then you could lose the benefit of workers' compensation insurance, state disability insurance, unemployment. So those are problems. And then again, if you go and you work for somebody and they improperly classify you, you turn around, you file a wage claim, there's some risk that not only the business, but also the owners of the business simply have no assets which you could then access. There are funds that workers can access. And this is if, for instance, if you can't find someone to give them their last check, you send it off to the labor commissioner. That creates a fund that other workers that are unable to go after their employers or whether it's their business or individually to collect. There are some funds available, but that isn't guaranteed. And it takes a really long time. Right now I'm seeing that if somebody goes online, files a wage claim, it's under investigation by the labor commissioner for a few months, and it can take even longer to get through the end of a wage claim and get paid. And then if the employer appeals the labor commissioner's decision, then it goes to court. So it could mean that you don't get paid for years and years and years. So I think that the real risk for the worker is that it's going to take a long time to recover the money. And if it's becoming an issue, it's probably because you need the money.
Awesome. Next question here. So you talked about how employers are really on the defense in a lot of this. And so say there is a situation with like employee theft. Unfortunately, this happens in the cannabis space. They do get paid out their wages appropriately and so forth. At that point, once they've taken care of the obligations that you've gone through here, do they have more anything on their side to help with recourse for the discretion of the employee at that point?
Sure. Well, in terms of what is the hirer's, what remedies are available for somebody that stole from you, right? So you can still file civil actions against them. You know, if product goes disappearing, you have to report that to the DCC. It's going to provide some documentation. So you could certainly try to recoup losses from a former employee, you know, through civil litigation, filing a small claim, whatever that looks like. It's always going to vary because the standard for it to be intentional and willful misconduct by the worker is pretty high compared to what's usually happening. I mean, theft aside, but generally when you're letting somebody go, it's not because they're stealing from you. It's because they simply aren't performing, you know, in a way that you had anticipated based on their disclosed experience or whatever skills they contended that they had. And it turns out they're really bad at their job. So, you know, you can't go after somebody for just not being a great worker or a bad fit. But if they're stealing from you, there's absolutely ways that you can go and have that investigated, get a police report filed. That's probably going to come in handy later. As a practical matter, you really want to weigh the pros and cons of whether or not it's worth it. If they stole $500, you know, and your best equipment from the farm that's not valued at, you know, maybe another $500, you're probably going to spend more time and energy than that $1,000 is worth to recoup. So it's really tough because, you know, people often come into my office and say, listen, Sarah, look, he did X, Y, and Z, and he took this and he was a horrible worker and he said terrible things about me on the group WhatsApp threads. What can I do? And oftentimes a part of my job is to sort of, you know, try to calm them down and bring them back into a world of, let's look at this from a business perspective and whether if economically it makes sense to continue to pursue this or try to make it right. Because oftentimes the cost of making it right isn't worth the peace and money you'll save for just letting it go and changing how you are interacting with workers in the future.
Great. I think this answers this other question too, which was what kind of recourse do employers have for employees who steal?
Yeah.
And I guess to add to everything you just said is, and correct me if I'm wrong, but the recourses that you just laid out, these are only applicable if you had them filed as legal employees to begin with. If you are not paying, if these people are not classified on the books, like there is no, is that?
I mean, you certainly could, if you had somebody that was on the farm working and you had promised them that their payment was going to be, for instance, 20% of the net profit, and then it was a completely unlawful classification. They steal some product from you, you report that missing product to the DCC and otherwise take the required steps. Is it worth the risk of trying to go after them to recover for their wrongs and what they took from the business, when the more likely fallout is going to be you're going to trigger all sorts of investigations from the EDD, the DIR, you know, possibly the county, possibly the DCC. You are opening up the floodgates of potential liability for the business that will probably cost you more than getting back whatever they took from you. So you need to sort of look at it from a practical perspective. Did you make poor decisions as the hirer that may put you in a position where it may be risky to try to pursue recovering those losses from somebody that you hired under an unlawfully classified working relationship? And in my experience, the answer to that is almost always nope. Sleeping dogs lie. Don't poke the bear. They probably won't file a wage claim. But really try to learn from those experiences. You know, it often takes something like this for people to understand just how earth shaking these employment law claims can be. take it on the chin, learn your lesson, and implement compliance strategies going forward. And don't do it in the first place.
The next question, this is more of a comment. Based on personal experience in a different industry than cannabis, it makes sense to learn all of this because an employer cannot win before the labor board. I had to pay all kinds of penalties for doing something my employees had asked for. Avoid the labor board if you can.
Absolutely. I always say when somebody comes to my office and tells me that they've been threatened with a wage claim, or they received a letter from the labor commissioner indicating that somebody had filed a wage claim, generally the strategy is going to be, how can we resolve this sooner rather than later? Because it's incredibly difficult to win the wage claims because so many of the presumptions are in the favor of the employee. And it's very difficult to be in perfect compliance in California. Keeping the records, making sure that all of the line items on the wage stubs are there, that can get really unruly. I'm an attorney that's been doing employment law since I first became a lawyer back in Arizona, and it's difficult for me to make sure that I'm always complying. And it factors into my decisions as to whether or not to have staff. So I agree with whoever made that comment that it is probably going to result in some amount of liability for the employer. And once you factor in all of the money that you're going to pay in associated penalties, paying an attorney if you decide to have an attorney at a labor commissioner hearing, it's usually better for everybody involved to offer some money up front. You're going to save yourself some penalties, save yourself some attorney time, save yourself the months that it's probably going to take to get these things worked through that system. And the laborer in the beginning is when they're most likely to accept some sort of negotiated resolution, because it gets them some money immediately. And oftentimes these wage claims get threatened because people are desperate for money. So to the extent you can resolve them early for something within the bounds of fairness, I generally recommend that because you're likely to have, some exposure when you go to a labor commissioner hearing. Not always that, talk to a lawyer when you're facing that. That may not be the case. And then there's some practical things, for instance, in the cannabis industry, folks are often getting paid with cash. Even if you're completely compliant, you're remitting the taxes, just because of the banking situation, folks receive cash, make them sign for it. If you had somebody that was working on some sort of profit split agreement and you weren't paying taxes for them, they weren't paying their worker taxes, but you did indeed give them some money, and that could be a significant amount of money, make sure that's documented. Have something in writing that they sign when you hand the envelope of cash. Because if they turn around and file a wage claim against you, you're going to get some offsets based on the money you've already paid. You may still be required you'll likely still have to pay associated taxes. But anything that you can document is going to give you some help if it demonstrates that you complied with some responsibilities as a hirer.
Yeah, one of the other things I'll just mention that I know comes up and is not wage related, but in terms of the level of appeasement that employees leave your property with. I would also say this is true for any contracted work that you're having, if it is, greenhouse technicians or, building constructors, whoever that is on your property. I have heard too many stories of just anonymous complaints being left for the licensing agencies, whether it's your local county licensing department or the DCC on the state level, and they will that can very likely cause unnotified inspections. Look into those complaints.
Yeah, and that's a great point. Thank you for bringing that up. It is true that sometimes people will file a complaint with an agency, whether that's the county, the Cannabis Compliance Department, the DCC, any number of agencies folks can submit those complaints to. And even if they're doing it in a malicious way because they want to cause you trouble, because they feel that you wronged them in a completely different context, right? So let's say that they are claiming that you were pulling a bunch of water from that creek that runs back and you're not supposed to. But they also think that you owe them a few $100s. And so they turn around, they report you to the water board, the DCC, and that triggers an investigation, even though it has absolutely nothing to do with their underlying complaint. Keep in mind that that's probably not going to stave off an inspection that can result from one of these complaints. But even if they're just calling and telling the DCC or the labor commissioner, hey, they're calling everybody an independent contractor. They're not giving anybody breaks. We're all working overtime and not getting paid. We have to work through lunch. Even if it's directly related to their complaint, there's whistleblower protections that will come into play. So you're not going to be able, you're very unlikely to be able to prevent a retaliatory inspection that is caused by somebody submitting a claim bogus or real, because the public policy behind that, is going to generally protect their identity. But more importantly, generally you're signing up for these sorts of inspections when you sign off on your permits and your state licenses. So it's always good to just be nice to people, even if they're awful. We may get into fights with our romantic partners or our family and things get really emotional, but in the business arena, it's really helpful to try to just give yourself some space and find your calm. It can prevent, it's amazing to me how many problems can be prevented by just taking the high road and being nice, even if you're having to fake it with someone that's driving you insane. It's usually beneficial to just be professional, to be kind, to view all of their flaws through an angle of, this isn't really about this situation. There's other stuff going on in their life. It can only help you to be a nice human. And that applies in all aspects of life.
I agree. Cheers to that. If anybody else has questions, please feel free to type them into the Q&A or the chat section while you have Sarah here at your ready. I see there is a hand raised. Diana, I will allow you to talk.
Hi, Sarah. Hi, everybody.
Hi, Diana.
Just wanted to say you're brilliant, Sarah. Thank you so much for dropping all this knowledge. And I just want to say thank you.
Thank you so much for having me.
We're so lucky to have you in the community. Thanks for doing this for us.
For anybody that's not a member of the Alliance, I just want to plug quickly how valuable it really is. Talk to Maggie about the other member benefits. The Get Legit webinars are available to the general public. But there's other benefits that are specific to members, including the Slack channel, the buddy program. I just really encourage everybody to explore that and see, because I think that if you will make use of any of the benefits, it's worth the cost of membership. And we get a lot done here in Nevada County because we have really strong collective efforts from the local cannabis community. So try to support them if you can.
Something else I wanted to mention just before we end today for everybody on the call, employment and labor related, we are planning to facilitate either June or July of this year, a 30-hour general Cal OSHA training for the cannabis sector here in Nevada City. And so please stay tuned for that. This is a requirement. Cal OSHA is very real. And I just will highlight, I know Sarah and some other folks saw there was a recent national, just really tragic article about a cannabis manufacturing company where a worker died from, it sounded like asthmatic sort of inhalation issues. And workplace safety and things like that are incredibly important to keep in mind. And so stay tuned for the Cal OSHA training that will be available this coming June or July here in Nevada City. And I just want to remind everybody that the next Get Legit webinar is all about prepping for audits. And which is also something you can expect as a business owner. That'll be on February 16th, right here. You can register online at nccannabisalliance.org and on the Get Legit tab. And just really appreciate you, Sarah, for sharing with us today. Sarah's contact information is also on our website, and you can reach her for more information. Rosemary, I see you have your hand up. While we're here, I want to let you speak.
Hi, can you hear me?
Yes.
Yep.
Oh, great. Thank you. And thank you for all this information. This is amazing. Just that, based on what I kind of gleaned from what you were saying between the difference between having a salaried employee and a wage earner. It just kind of seems like it's more safe to just call them a wage earner so that there is no dispute um, about how many hours were worked and that kind of thing. Does that make sense?
Absolutely, I would agree with that. You know, there are some situations where the salaried relationship makes sense. So for instance, in the legal profession, attorneys often have workloads that go like this. You know, particularly if you're working in an urban area for a big firm, you may have weeks where you're working 20-hour days because you're in trial, for instance. And then, you know, what they're trying to do is sort of spread that out across the year. So for really high level employees that are making really, really good money, I mean, I'm talking 80 to 100 plus, at that point, it may make sense because it gets really difficult to start calculating the overtime. If you're paying somebody 40, 50 bucks an hour as an hourly employee, and then you have a big work push that's going to create significant overtime exposure, at that point, it's probably worth looking into whether to spread that out across the year throughout a salary so that you're paying them a little bit more when things are kind of slow, but when things are bonkers, you're not having to pay a bunch of overtime at once. So I do think that for the most part, you know, folks that are working on a small cannabis farm, the owners are generally the primary head farmer that are really running the show, particularly, you know, the farmers I'm familiar with here in Nevada County, and then they may have some laborers, but the general sort of wage scale for those types of employees, I agree with you. I don't think it often justifies making them salaried.
Gotcha. Thank you for this information. I have some calculations to do.
Yep, I hear you.
Awesome. Well, with that, I will give everybody their evenings and hope you enjoy them. Thank you so much, Sarah, and thanks everybody for tuning in. This webinar has been recorded and will be available online in the near future. We have a full YouTube playlist. I recommend checking out all of our Get Legit webinars, which you can find again on our website at nccannabisalliance.org/getlegit. Thanks so much and see you next month.
We'll do it again next year. Thanks, everyone.